5 seconds to go. Start. Admittedly, the promotees were entitled to their fitment within 25% quota. Vacancies for the promotees had arisen on 3rd May 1979 and therefore VP Mishra was entitled to that vacancy which arose on that date. However, as stated above in the integrated list, the promotees were pushed down. It was contended on behalf of the promotees that the direct recruits were not born in the service when the promotees were promoted, and equity requires that the promotees cannot be pushed down. This court rejected the said argument by observing that the object of direct recruitment is to blend talent and experience. So long as the system continues, consequences are inevitable. Although the direct recruits were recruited later, their fitment in the order of seniority had to be determined with reference to rota and quota prescribed under the rules. In such a case, there was no illegality even when promotees were pushed downwards in the order of seniority. In our view, the judgment of this court in S.D. Gupta squarely applies to the facts of the present case. It was held that although certain direct recruits were recruited subsequent to the promotees, their fitment in the order of seniority had to be determined with reference to rota and quota or rotation of quota prescribed under the rules. It was held that there was no illegality when the promotees were pushed downwards in the order of seniority. This court quoted with approval its earlier judgment in the case of Union of India and others versus S.D. Gupta and others. In this case, by applying the principle of rota and quota, the inter se seniority of the promotees and direct recruits was fixed. This court in the said case held that though direct recruits were recruited subsequent to the appointment of promotees, the fitment of direct recruits and promotees must be determined with reference to the rota and quota prescribed. In paragraph 8, this court dealt with an argument that the direct recruits were not born in the service when the promotees were promoted and therefore the promotees should not be pushed down. In paragraph 8, this court held thus: it is then contended that the direct recruits were not born in the service when the promotees were promoted, and equity requires that they cannot be pushed down. The object of direct recruitment is to blend talent and experience to augment efficiency when direct recruits, though came from green pastures, were imbued with dedication and honesty. So long as system continues, consequences are inevitable. The question of equity does not arise. Sri Krishna Mani then contended that direct recruits are shown temporary and so they cannot be similar to promotee substantive appointees. The quota of 60% of direct recruits is to substantive vacancies, though their initial appointment is temporary. On completion of period of promotion, they became substantive appointees. That is the settled principle of law in this behalf. The tribunal therefore is not right in giving direction to consider their fitment vis-a-vis the order passed by this court in their quota above the direct recruits. Now we turn to the decision of the Constitution Bench. This court decided a petition under Article 32 of the Constitution of India filed by the appraisers in the Customs Department. The Constitution Bench noted that the system which prevailed for recruitment to the posts of appraisers was that 50% of posts were reserved for direct recruits and the remaining 50% were filled in by promotion from subordinate officers in the Customs Department. The contention raised in the petition was that this system had resulted in discriminatory treatment to the promotees inasmuch as the promotees who had rendered much longer service in the cadre of appraisers were put in seniority below the direct recruits with much shorter service. There was one more grievance in the petition with which we are not concerned. The Apex Court referred to the circular OM dated 12 September 1959, which is referred in the OMs dated 7 February 1986 and 3 July 1986. After considering the submissions, the Constitution Bench held thus: Before we come to what has been done in 1963 in the matter of fixing seniority of appraisers, we may refer to two other circulars. The first is a circular of the board issued in 1953. That circular, in our opinion, has nothing to do with the question of fixing of seniority as between direct recruits and promotees. Its main value is that it emphasizes that the proportion fixed for direct recruits and promotees should be rigidly maintained. It also directs that promotion to higher grades should be made on the basis of a combined seniority list of both direct recruits and promotees. Then there is another circular of 1955. That circular again emphasizes the rotational system and says that it has been decided that inter se seniority of direct recruits and promotees in the grade of appraisers should be determined in the order in which the vacancy in that grade is filled by a direct recruit or by a promotee according to that quota fixed for such appointments. Stop.